things and that we've talked about before is health and safety, and some of the things that you were talking about too, Jeremy, about making sure the distancing is happening, making sure that the site is doing all the things that are necessary in order to protect everybody that's working on the site. And I think, well, even as a law firm owner, that's a challenge for anyone who's running a business in the current environment, is to make sure that everybody who is working is protected and that the things are in place to do that as best as possibly can be done.
I think one of the things to play out in the future, Jeremy, is the situation with how the industry, whether the industry is mature enough to be able to have a different think about EBAs, because cost of your labour is your biggest cost, and whether or not businesses can afford to just keep on signing off very generous EBAs in this environment is a conversation that needs to be had, because the typical EBA for a particular worker is twice the award wage at the moment. So in a time when you're looking for productivity, the best productivity gains you can get just to keep the business going, that type of locked-in cost is pretty hard for a business to afford.
Yeah, I think that...
Sorry, you go, Jen.
You go, Jen. I was going to say, I think it's less of a concern for us in terms of labour costs, although that is still a significant cost over here. For us, we've seen from the consultancy side, a few of our clients are starting to see a bit of a slowdown in the pipeline of work that expected. So that's kind of concerning moving into the future. But bigger macroeconomic issues that are affecting the Middle East that might not be affecting Australia quite as much as the drop in the oil price. So a lot of people within the Middle East were sort of looking to Saudi Arabia as the next sort of boom market, and their project pipeline was just incredible. Some of the projects there were massive on a scale that has been very rarely seen anywhere else in the world, and it was really ambitious. And with the drop in the oil price, we're starting to see that some of the works that had been sort of forecast to be, within the next 2 to 3, 4 years are now sort of in the next 10. And there are now sort of payment issues which are starting to arise on those projects. But Saudi Arabia is certainly sort of one of the next markets for us, maybe Africa, and a few of the Middle East projects in terms of civil packages and stuff will keep getting released, but definitely been a slowdown over here.
Got a question from the floor from Graham Top for you, Jeremy. In your view, what are the top 3 causes of dispute in your neck of the woods? Is it latent conditions? Is it defects? What's your top 3 causes of dispute?
Delay. Delay is certainly probably the top, I think. Wherever you construct around the world, there's going to be the key sort of issues: time, cost, delay. So for us, it's probably like cost overruns and variations, time, defects, less so. There's certainly concerns with defects, but I don't think that the defects make up the biggest portion of what disputes typically will be about. Generally, it's going to be delay.
I find it hard to get my head around a construction practice where there is no adjudication. It's just been such a huge part of practicing as a lawyer here in Australia for the last 16 years. The entire time I've been a lawyer, it's just been front and centre and seems to get more and more momentum and deal with bigger and bigger projects all the time. There was a lot of years there, and I still have a bit of fun doing this, but testing the limits of what the legislation means and, taking things before the Supreme Court to work out exactly what these words in this legislation mean and how far we can push it. So, it's hard to get my head around during a jurisdiction where that kind of tool isn't in the bag of tricks. And I can see what you say about there being a an affection for moving towards arbitration in those circumstances.
Yeah, I mean, I think Scott mentioned it in the comments a little bit earlier. There is a way that you can get an ex parte decision where you have certainty of payment. So where they've guaranteed to make payment of a certain amount, you can apply to the courts and get a decision. But it has to be very, very clear on the papers that it's really everything's been confirmed. So the evidence needs to be really strong in that regard. But for us, as a result of almost not having the fallback of adjudication, not being able to submit your payment claims, which adjudication was a massive part of my early career in Australia.
Yeah, of course.
Like it's all I did. It makes perfect sense that coming over here, it's just such a shock as well. You go, well, there's nothing here. So there is this sort of roll-on effect of not having the ability to refer things to adjudication, in that you now start to have these sort of balance sheets that start escalating and escalating and escalating. You know, these dispute claims that just sort of sit on the side, which will slowly compound until it gets to the stage where, you know, say the project is coming to completion, you've almost got no choice as to, you know, what you do. It's like, well, unless we can somehow commercially settle this, which is a very large discrepancy, we've got no choice but to go to some form of formal dispute resolution. And whether that's the employers have elected to go to the courts, or whether there's been an agreement to go to arbitration, you'll have to resolve it some way.
But does that mean that basically the disputes would just, you know, log up till the end? People won't be going midpoint? Is that, if I'm making sense?
Yeah,
okay.
No, that's kind of what it started to shift in the last few years. I'll say that, where margins have been shrinking and the risk profile has been getting slightly higher, people are more willing to commence proceedings earlier in the process. We've definitely seen that, but typically in the past, I'm talking 5 or 10 years ago, from what I understand, I've only been in the region for a bit over 3 years now. What would have happened is handshake agreement towards the end of the project. Okay, we'll get the owners of the companies together and we can sort of hash this out. We'll get close and then potentially have a meeting to resolve it. But there are less and less of those meetings happening, and people are more willing to commence formal proceedings earlier in the project. But it's not uncommon to see these large disputes sort of, you know, building up and building up and building up.
We've got a question from the floor again, one from Sarah in the UK. Her question is in relation to insolvency and the risk of insolvency in your neck of the woods. So in Australia and the UK construction industry, she's saying it's one of the highest industries, with the rate of insolvency as the highest. And is it the same over there? Have you seen insolvency numbers rise during the COVID crisis?
We were seeing insolvency numbers rise before the COVID crisis. So it's certainly on the rise, and it was sort of on the rise in the last sort of year and a half. So I think COVID might have accelerated some of the companies that were struggling. And I think the impact is probably going to be felt even after sort of the pandemic is resolved, whether there's a vaccine or however it's resolved, because of the slowdown in the work that's going to come through the project pipeline. So some of those companies that might have already been struggling have probably just been, you know, that's been put on fast forward.
Exacerbated, yeah.
So is there dire consequences for people that, you know, directors of companies that become insolvent? Can they just sort of brush themselves off and start off again?
It's a bit stricter over here. And I'm certainly not an insolvency lawyer, but I do know there was a change to the insolvency law last year to make it not a criminal offence anymore. So yeah, it used to be quite a serious offence, but now there's a certain amount of directors' duties that are obviously owed, and you know, if you're trading while insolvent and you don't notify the board accordingly, or if you receive bankruptcy proceedings and you don't call a shareholders meeting to advise within 30 days, there's personal liability that will then attach to the director. But from a sort of personal liability point, it used to be quite high, and it's been backed off a little bit.
Okay.
Jesse's asking if dispute avoidance boards are used at all, Jeremy.
In our cases in Africa, yes, we'll see DABs, DAABs used a fair bit. They're really helpful in sort of resolving the issues as they arise. I think it's a really helpful tool if it's used properly. We know of a DAB, I think Scott's just, a DAB on Expo 2020 that's being used. So the Expo site has been a major form of our construction stimulus over the last sort of 2 years. So getting the whole Expo site up and ready, and a DAB has been used on that. And we know that there's been some success in that because it does have the effect of being able to be put in place as and when an issue arises. You get almost an interim decision. The employer will likely know where they stand, the contractor will likely know where they stand, and things can sort of move forward. Typically, for every other contract that we deal with in the region, that provision is struck out of the FIDIC standard form, and there's either a tiered dispute resolution process where it will consider amicable settlement before it then proceeds to a meeting between the directors, and then finally commencing formal proceedings.